Good evening, friends. The question is, if the client changes his advocate, legal advisor in between, and there is dispute of payment, can he keep the briefs with him? Can he keep the file with him? Are the files goods under the Sales of Goods Act? So these are the issue which I am going to discuss. Friends, I may tell that I am talking about one of the case law, that is R.D. Saxena versus Balram Prasad Sharma, AIR 2K, Supreme Court 2912. This is the title of the case. Friends, this case deals with the question of occating files and copies of the records with goods. Second issue, it decides whether the advocate has lien over the briefs filed handed over to him for non-payment of fees. The two issues I am going to dive into in detail. Firstly, I am sharing the facts of the case. Here, the appellant is now advocate, as he is convicted. So he is before the Supreme Court. The appellant was an advocate and also served as a legal advisor to the Madhya Pradesh State Cooperative Bank Limited. The bank hired him to handle legal matters in which the bank was involved. However, the bank ended his position and asked him to give back the files related to the bank. Instead of turning the files, the lawyer refused and insisted that the bank first pay him his due remunerations, legal fees for his legal services. The bank was in need of files for ongoing legal cases, but they disagreed with the lawyer's demands, considering them unreasonable. As a result, the when the managing director, the bank, was unable to take files from him, they filed a complaint with the State Bar Council, Madhya Pradesh, on 3rd February 1994. The complainant accused the lawyer of professional misconduct for not returning the files. During the proceeding, the lawyer admitted to not returning the files, but argued that he had the right to keep them using his right of lien. But it is also true that there was gray area at that time, whether he can keep the files or not. So that gray area was there. He offered to return the files once the bank paid him for his legal work. So, friends, the law point involved here is whether the advocate has a lien for his fees on the litigation papers entrusted to him by the client. This is the legal issue. The Honorable Supreme Court gave its observation and stated that files and records held by an advocate do not qualify as goods that can be withheld for unpaid fees. They further said that the goods as defined in the Sale of Goods Act 1930 do not include legal records. So it does not come under the definition of goods as per Goods Act 1930. Then in the defense, the issue raised was of bailment. The court clarified this contempt also The concept of bailment, defined in Section 148 of the Indian Contract Act 1872, involves delivering goods with an agreement for their return, which do not apply to legal files. So this defense was also not acceptable. The court emphasized that withholding records for unpaid fees could harm the client's case. An advocate should not have the right to withhold records due to unpaid fees. Instead, they can pursue their legal remedies for payment. If a client changes the advocate, the former must return the case file and disputes or fees should be resolved separately. The court stressed the social duty of the legal profession to support people, ensuring they are not deprived of their rights due to an advocate's position. While advocates can set fees by agreement, unpaid fees do not justify withholding clients' documents. The court further gave a beautiful example. Suppose you are before a doctor, you are getting treatment. What you want to change the doctor in between, and there is dispute. I will not give the details of the medicine, details of how he cured the person. So the life of the patient will be at risk. So the court said, you can't have a lien on the paper. Please hand over the papers. So nutshell conclusion is the court held that the appellant was guilty of professional misconduct and denied any right to retain the record of the litigation entrusted by the bank, and also urged that legal records do not amount to goods under the Sale of Goods Act. That's all, my friends. So he was held guilty of professional misconduct. Be careful in future if the type situation comes before you. Thank you for watching. See you again.